please do that also. I also want to picture. ठीक है.
A very warm morning to each one of you present here. At 3.9 degrees Celsius, Delhi has had the season's chilliest morning today. But looking at the participation we already have, we are delighted by the warmth and affinity being extended. Ladies and gentlemen, it is with great pleasure and immense pride that I welcome each and every one of you to the first National Convention of Insolvency Professionals and Registered Valuers. This gathering marks a significant milestone, bringing together brilliant minds, passionate individuals, and visionary leaders from all corners of our great nation. This landmark event is proudly hosted by the ICSI, that is the Institute of Company Secretaries of India, jointly with the ICSI Institute of Insolvency Professionals and ICSI Registered Valuers Organization. Our presence here is a testament to the dedication and expertise that each one of you brings to the field. In a rapidly changing economic landscape, the role of insolvency professionals and registered valuers is more crucial than ever. We are the architects of financial resilience, ensuring the integrity and stability of our economic system. May this convention be a catalyst for a positive change, a source of inspiration for all, and a symbol of boundless potential that lies in this ecosystem. Thank you for your attention, and we are eager to engage in a fruitful discussion throughout our time together today.
Today's convention revolves around the theme Insolvency, Bankruptcy, and Valuation, Achievements, Challenges, and Expectations. This theme encapsulates the very essence of the work we do, the hurdles we face, and the promising future that lies ahead. This forum serves as a platform to collectively address the achievements, challenges, and expectations in the realms of insolvency, bankruptcy, and valuation.
Thank you, Anu. Now I request our special guests, Honorable Ashok Kumar Bhardwaj, Member Judicial NCLT, CS Manish Gupta, President, the ICSI, CS B. Narsimhan, Vice President, the ICSI, Mr. P.K. Malhotra, Chairman, ICSI IIP, Dr. Navrang Saini, Chairman, ICSI RVO, and CS NPS Chawla, the Program Director and Council Member, ICSI, to please join the dais. Let us all stand up for the motto song of ICSI that is at heart of all of the company secretaries.
उम्मीद के अंबर में हम बन के खिले जो रोशनी, कह देंगे हम संसार को कोई लक्ष्य नामुमकिन नहीं। ज्ञान के और न्याय के हर राह को थामे हुए चल पड़े हैं झूम कर बस गीत ये गाते हुए। सत्यम वद धर्मम चर, सत्यम वद धर्मम चर, सत्यम वद धर्मम चर। कंपनी सचिव कदमों की हर एक गूंज में बस जीत का एहसास हो, राष्ट्र प्रगति पथ पे हो और आत्मबल की आस हो। जब भी चले इस भाव से खुलते गए हैं रास्ते, आवाज हमने दिल से दी है गीत ये गाते हुए। सत्यम वद धर्मम चर, सत्यम वद धर्मम चर, सत्यम वद धर्मम चर। हर उन्नति के रंग में हर भारतीय हाथ हो, उद्यम हो या उद्योग हो, हर ओर अपना साथ हो। जाना शिखर तक है हमें सच की कलाई थाम कर, हम जीत के सुर छेड़ेंगे गीत ये गाते हुए। सत्यम वद धर्मम चर, सत्यम वद धर्मम चर, सत्यम वद धर्मम चर।
Now I would request CS Manish Gupta ji, President ICSI, to kindly felicitate Honorable Ashok Kumar Bharadwaj ji, Member Judicial, with a planter, shawl and memento. I would request CSB Narasimhan ji, Vice President ICSI, to kindly felicitate Mr. P.K. Malhotra. I would request CS Manish Gupta ji, President ICSI, to kindly felicitate Dr. Navran Saini, Chairman ICSI RVU, with a planter. Let's have a big round of applause, ladies and gentlemen, for all the dignitaries present on the dais. I would now request CS NP Chawla ji, the Program Director and Council Member ICSI, for the welcome address.
Yes.
Thank you. Honorable Mr. Ashok Kumar Bharadwaj, Mr. Manish Gupta, President ICSI, Mr. Narasimhan, Mr. Malhotra, Chairman of ICSI IIP, Dr. Navran Saini, Chairman of ICSI RVO, Honorable Mr. N.K. Bhula, former member NCLT, Mr. A.K. Chaturvedi, former Regional Director, Northern Region, my Central Council colleague Mr. Manoj Kumar Purbe, my other Central Council colleagues joining virtually, Regional Council members, senior members, insolvency professionals, registered valuers, company secretaries, officers of the institute, friends, young students. Many students have joined today in a chilling day in January on a Lodi day. Good morning all of you. At the outset, wishing everyone a very happy new year. I think this is the first time we are meeting in a program with members in the new year. May this new year bring a lot of happiness, joy, prosperity, particularly for all professionals, and good health. Today, fortunately, coincidentally and fortunately, is a festival, Lodi, which is named and called by different names, Pihu also and Bihu also, and there are 5-6 festivals which are celebrated today. And when we fixed today's date, I shared with President, today is Lodi. He said, but we honestly don't have many days because we had already planned this program in December, but somehow we were seeking availability of honorable members. Unfortunately, we earlier requested Chairperson NCLAT, today being Lodi, His Lordship is travelling to Allahabad. Justice Sudhakar, President NCLT, His Lordship is also travelling to his hometown in Chennai. So we still thought that we will try our luck, and fortunately, Honorable Mr. Ashok Kumar Bhardwaj, Member Judicial NCLT, kindly agreed to grace the occasion, and Honorable Justice Sikri, Honorable Justice A.K. Sikri had to come. In fact, I went to his place today in the morning. I came here early in the morning, and then I had to go to Justice Sikri's house to receive his lordship. Unfortunately, he was really unwell. I reached his house. His assistant said, "Sir, office mein baitho." I sat there, and he said, "Sir, aap baat karo. Yahan network nahi aata basement mein." And sir was not able to speak. He said, "Yaar, NPS mein rati kithe gaya si?" I went somewhere at night, and mainu thand lag gayi. And he got that cold wave. And unfortunately, his lordship would not be able to join us, but his blessings are always with us. I still requested that if his lordship can join us virtually and bless us, because many members have gathered here to hear, in addition to Honorable Justice Bhardwaj's words of wisdom, in addition to Justice Bhardwaj's words of wisdom, also Justice Sikri's blessing, because he is veteran in this subject. But maybe some other day we'll have that fortune to hear his lordship. Friends, this idea of having first national convention came to our dynamic president's mind, and he is IP, I am IP, and we are involved in many activities of ICSI IIP from its inception, being shareholder, nominee shareholder, directors, members of grievance committee, members of many other committees. And President thought that we always do a convention of our members but not insolvency professionals, and let's give a platform where all our insolvency professional and registered valuers do come and share their concerns, share their apprehensions, share their expectations also, because this code has a lot of meat, and I feel we already have reached up to one level, but still sky is the limit for insolvency professionals. I feel globally, if you see the kind of recognition which insolvency professionals have attained, certainly here also insolvency professionals are backbone of this IBC ecosystem. This is what I personally feel. And with this background, President thought that we should organize this program, and then we came up with this idea. The theme is what we actually feel is true, that we have achieved, and only with the expectations which legislature had from all the stakeholders of the IBC ecosystem, and particularly you all, because without you being here, you are the backbone. I feel insolvency professionals and registered valuers are the backbone of this IBC ecosystem, and then the backbone would not survive without the brain. So the real brain are the judiciary, and that's how we requested Honorable Justice Bhardwaj also to come and bless us. I have had the good fortune of appearing before Justice Bhardwaj in many matters, and I feel his lordship is very, very, very humble and always available to hear matters at length, to encourage young members, to encourage insolvency professionals to hear their difficulties, to hear them at length, and then pass a very fair and reasoned judgments. In fact, big round of applause for Honorable Justice Bhardwaj for sparing his valuable time today early in the morning. In fact, As far as I see him, he is a champion of fairness in the complex landscape of corporate insolvency and restructuring. I would also say, Honorable Justice Bhardwaj's journey to the NCLT is a testament to his unwavering dedication to the legal profession and an unyielding commitment to upholding the principles of justice and equity. Honorable Justice Bhardwaj did his graduation from economics as one of the optional subject, and thereafter his lordship also did a subject in masters in corporate law. He was enrolled as lawyer in fact many years back, before many of the youngsters were even born. In 1990 your lordship did his law and became a lawyer, then did many matters pro bono, which I got to know today, and then your lordship was appointed as ACGSC with effect from 1997 and was senior government counsel from 2004, represented government in many matters before high courts of Delhi, Guwahati, Chandigarh, Allahabad. Lordship also represented Union of India before CAT and was then the standing counsel for Prasar Bharati. Then was his lordship was appointed as judicial member in CAT, from where his lordship had resigned and then decided many matters in his tenure there in CAT, and thereafter joining NCLT recently in 2022 as judicial member. So big round of applause for his lordship for taking out time for today's program. Friends, we have divided the theme in such a manner that the program is not only talking about achievements. The theme certainly talks about insolvency, bankruptcy and valuation, because these two subjects are intrinsically attached. Without valuation, insolvency would not be achieved, or the resolution of insolvency would not be achieved, or one can say because the bad valuation one would reach to insolvency, and then ultimately with the correct valuation one would be able to resolve the insolvency. And that's how the president thought, why only. In fact, when president gave this idea, I said, okay, let's do this of ICSI IIP. Then president corrected me. He said, sorry NPS, we'll have the ICSI RVO, Registered Valuer Organization, also joining the program, and we'll have our valuers also joining the board, and then have this program jointly. Friends, the idea is not to only have achievements highlighted. We need to know the challenges so that we can accordingly make a representation to the government. It will be an interactive panel discussions. Today we'll have 3 panel discussions. I'm bound to share the theme. The theme you have already seen. The program would be the first panel discussions, where we'll have legal luminaries and we'll have quandaries. In fact, I coined this topic because I feel there are so many quandaries. Now Justice Bhardwaj decides one matter which goes up to appeal in appellate tribunal, upholds my lord's view. Then ultimately there may be a different view, like in the Amit Metallic Judgment of Security Interest in relation to the security interest in section 53 and section 30. Now that issue was decided by Honorable Supreme Court in Amit Metallics, but ultimately now it has been, in one of our matters, has been upheld. It has been referred to the larger bench by Justice Sanjeev Khanna in Supreme Court. So there are many matters like this where the law is still being settled. There is a lot of settling and unsettling in this subject because this is a new area, and that way we thought we'll have that first panel discussion, and second is on pre-pack, because pre-pack has not picked up. We still need to know from you what are the difficulties so that we can give that representation on behalf of the institute and IIP to the government. And then the third post-lunch session would be on valuation, which is art of valuation in insolvency cases. We are always available for you and for your concerns. If you have anything to share with us, we'll be always available. That's all in the beginning. I again thank Justice Bhardwaj and also Mr. Malhotra and Dr. Navrang Saini for being here early in the morning, and always, in fact, Mr. Malhotra and Dr. Navrang Saini are part and parcel of our IIP and the RVO. They are always available. So big round of applause for all the 3 dignitaries available here. Thank you, sirs.
Thank you, sir, for the warm introduction. That was indeed a great start for the program. Moving on, ICSI Registered Valuers Organization is a Section 8 company formed by the Institute of Company Secretaries of India to enroll and regulate registered valuers as its members. At its core, ICSI RVO is dedicated to promoting and regulating the profession of registered valuers, ensuring that it aligns with the highest standard of competence and ethical conduct. Recognizing the critical role that valuations play in financial transactions, insolvency proceedings, and corporate decision making, RCSI RVO sets out to nurture a community of experts committed to delivering accurate and reliable valuations. With this background, I would request now Dr. Navrang Saini to please join us on the dais. Please give a huge round of applause here.
Honorable Justice Ashok Kumar Bhardwaj ji, Member Judicial NCLT, Manish Kumar ji, President ICSI, Narsimhan ji, Vice President ICSI, PK Malhotra ji, Chawla ji, NK Bhola ji, Chaturvedi ji, Pavdia sahab, my colleague in the governing board of the RVO, other Central Council members present in the hall, dignitaries of the dais, insolvency professionals and registered valuers. Good morning to all of you. Well, I have been given the task to submit a progress report before all of you. We all are aware that the Ministry of Corporate Affairs notified Section 247 of the Companies Act 2013 in the year 2017 and subsequently notified the Companies Registered Valuers Rules 2017 on 18th of October 2018. The Ministry of Corporate Affairs also made the Insolvency and Bankruptcy Board of India as an authority to regulate the profession of registered valuers. Thus, the Insolvency and Bankruptcy Board of India is a regulator for both the professions which work together specifically in the insolvency regime, that is insolvency professionals and registered valuers. Initially, the three professional institutes, that is Institute of Company Secretaries of India, Institute of Chartered Accountants of India and Institute of Cost and Management Account of India, they came forward to form Section 8 companies as an RVO. So in that line, the Institute of Company Secretaries of India formed a Section 8 companies on 22nd November 2017. Since then, the RVO is working. So if we talk about the profession, as on today, there are 4,376 registered insolvency professionals, 118 IPEs, 15 registered valuer organizations, 5,494 registered valuers and 105 registered valuer entities. ICICI Registered Valuer Organization intends to enroll, educate, train and promote the profession of valuers as per the company's Registered Valuers and Valuation Rules 2017 notified in the year 2017 as of course as per the provisions of the Companies Act 2013. ICSI RVO is registered with the Insolvency and Bankruptcy Board of India in all the three asset classes, that is land and building, plant and machinery, securities and financial assets. However, the RVO is imparting training in the field of securities or financial assets only. We all are aware that Rule 8 of the Company's Registered Valuers and Valuation Rules requires a registered professional to prepare the report as per the internationally accepted valuation standards or valuation standards issued by or framed by the organization. To adhere the valuation standards, ICSI RVO embodies a commitment to integrity, expertise and adherence to stringent professional standards through rigorous training, certification and oversight, fostering trust and reliability in valuation processes. In a world where precision matters, the ICSI RVO stands as a cornerstone guiding and regulating valuers to uphold the integrity of financial markets, insolvency resolutions, and corporate decisions. Their dedication ensures that valuations are not just members, but pillars of the trust upon which significant economic decisions are made. Capacity of members is strength of any organization. Therefore, for continuous capacity building of its members, the ICICI RVO has signed memorandum of understandings with IOV Registered Valuer Foundation and RICS India Private Limited. The ICSI RVO has 4 publications to its name. First is Valuation of Securities or Financial Assets. Second is MCQ's book on valuation of securities and financial assets. Third is Guidance Note on Valuation of Securities or Financial Assets. And fourth is a book on valuation of land and building. The ICSI RVO has conducted classroom trainings and 28 online batches of 50 hours educational course from April 2020 to date, added 1596 valuers members to date, added 251 registered valuers to date, and conducted 20 continuing professional education and 9 certificate of practice programs from April 2022 to date. It has also conducted 6 webinars from April 2022 to date. In the current financial year, the RVO has added 96 valuer members and 7 registered valuers. It has conducted 5 online batches of 50 hours educational course attended by 91 professionals. It has conducted 8 continuing professional education and 2 COP programs. It has also conducted 2 webinars. First on a webinar jointly with RICS on the topic of ESG as the regulatory framework changes with the establishment of ISSB and reporting requirements under IFRS. What does it mean for real estate valuers and business valuers? Is it the same? Then other was webinar on demonstration of Proves IQ database with CMIE. So Chawla ji actually discussed about the challenges. So one of the challenges before the profession is to actually be, you can say, to be regulated by a national institute such as the Institute of Company Secretaries of India. Of course, the matter is already in consideration with the central government. A report has also been submitted. But unless the profession is regulated continuously by a national body, progress will be, I can only say that in a limited manner. But if the institute comes out, then definitely progress will be there. And I will conclude with the saying that ICSI RVO is continuously adhering to build the capacity of its members, and it will always continue. Thank you very much.
Thank you, sir. Your words have been inspiring, thought-provoking, and truly appreciated. Let us also acknowledge the presence of Dr. Ashok Kumar Mishra, formal member technical NCLAT and government nominee on the Central Council of ICSI. Moving on towards our very own ICSI IIP. The ICSI Institute of Insolvency Professionals is a Section 8 company formed by the Institute of Company Secretaries of India with an objective to enroll, educate, train, and also monitor the performance of its registered members as insolvency professionals. ICSI IIP serves as a dedicated platform for nurturing and developing the insolvency professionals who play a crucial role in resolution process under the IBC. The Institute aims to uphold the highest standards of professional conduct and competence amongst its members, ensuring that they are well equipped to navigate the complexities of the insolvency proceedings. With this background, to discuss the progress of ICSI Institute of Insolvency Professionals, we have none other than Mr. P.K. Malhotra, the Chairman, ICSI IIP. I would now request Mr. P.K. Malhotra to please come to the dais. Let us give a big round of applause to the distinguished personality. Thank you. Thank you.
Shri Ashok Kumar Bhardwaj ji, Honorable Member, National Company Law Tribunal, Shri Manish Gupta ji, President ICSI, Shri B. Narasimhan ji, Vice President ICSI, Shri Navrang Seni ji, Chairman of ICSI CVO, dignitaries of the dais, ladies and gentlemen. It's proud privilege for me to present a report on behalf of the ICSI IIP, which is an organization regulating the profession of IPs in accordance with the directions, rules, regulations issued by the regulator, that is the Insolvency and Bankruptcy Board of India. It's an honor and privilege for me to stand before you as the chairperson of ICSI, Institute of Insolvency Professional, in this first National Convention of Insolvency Professional and Registered Valuer being organized under the leadership of Institute of Company Secretaries of India. And today we are gathered here not only as professional, but as a community committed to excellence in the field of insolvency and bankruptcy, the objective which the government wanted to achieve when the Act of 2016 was passed by the Parliament. When we talk about the insolvency and bankruptcy landscape in India, we are witnessing a transformation that goes beyond mere legal framework. As you all know, the Insolvency and Bankruptcy Code of 2016 has been a game changer, providing a robust legal framework that ensure a time-bound and efficient resolution process. The IBC has remarkably altered how distressed and defaulting business are handled by the stakeholders. The preamble of the code emphasizes its purpose as timely corporate reorganization and insolvency resolution with the goal of maximizing asset value. Unlike traditional recovery-oriented tool, IBC adopts a resolution-oriented approach, that is, it allows the company as going concern despite the default. By focusing on the revival and continuity of financial distressed entities, the IBC seeks to preserve jobs, protect investment, and maintain the operational viability of business. The data as on September 2023 indicates that the creditors have realized 2.16 lakh crore under the resolution plan approved under the code. More than 26,000 applications having underlying default of 9.33 lakh crore have been withdrawn before their admission at the resolution process itself. The ICSI Institute of Insolvency Professional, under the aegis of Institute of Company Secretaries of India, has played an important role in this journey. Our membership is over 1,200 professionals, which include company secretaries, management experts, advocates, cost accountant, chartered accountant, and many other. Since its inception, ICSI IIP has been keeping its commitment to educate, monitor, discipline, train, and develop insolvency professionals. We have pioneered numerous initiatives, including the issuance of publications, monthly journal, daily learning course, and a range of educational programs such as pre-registration educational training program, workshops, interactive session, and webinars that focus on practical aspects and challenges faced by insolvency professionals. Some of the widely accepted publications of ICSI IIP are 100 Landmark Judgments of NCLAT, Final Word on IBC, Compendium of Insolvency Professionals, and Pronouncements under IBC, etc. ICSI IIP has also helmed statements of best practices on the subject such as COC meetings and collection of claims along with compliance calendars for the entire CIRP and liquidation process that has helped our members in expediting the entire process. I'm happy to share that ICSI IIP was the first organization in the country to introduce a monthly journal dedicated exclusively to the subject of insolvency and bankruptcy law. This publication stands as a testament to our commitment to knowledge dissemination and professional growth. Looking forward, ICSI IIP aims to evolve into a formidable supportive wing for insolvency professionals, aiding in their education and development. We strive to establish an effective oversight mechanism for monitoring and disciplining our professionals, ensuring the highest standard of professional conduct. I am delighted to announce the query platform, a testament to our commitment for providing timely and expert guidance. This platform allows our members to post queries on regulatory, practical and procedural aspects of the Insolvency and Bankruptcy Code, which are addressed promptly by identified experts in the IIP. Furthermore, recognizing the power of digital learning, we have introduced the Learning Management System, a user-friendly online platform offering e-books, expert-led online lectures, and e-mock exam to aid professionals preparing for the limited insolvency examination. As we continue to navigate the dynamic landscape of insolvency and bankruptcy, let us do so with a shared commitment to excellence, knowledge, and professional growth. I'm happy to share with you that in IIP we always try to maintain a balance between the interest of the investors, the functioning of the organizations which are working under the IBBI, as well as the role which IPs have to play to see that the objective of the act is achieved. I am also part of the grievance redressal committee in the IIP, and I find many a time complaints are received against the IPs which are motivated, but many a time we find some merit in that also. While we try to protect the interest of the IPs to ensure that unnecessary complaints are not entertained, at the same time, if in case we find that there is some genuineness in the complaint or there is some reason to be interfere, only in such matter GRC gives a direction. And I am happy to share with you that many of the complaints, rather majority of the complaints are filed with vested interest, and GRC doesn't take note of that and we just file them. But that's a message to all of you, that you must discharge your duty in accordance with the rules and regulations framed by the IBBI. If you are not doing that, then GRC will come heavily upon you and the natural consequences and the rule will follow. And I thought probably this is a platform where I can convey this message, being chairman of the ICSI IIP, to all the professionals who are involved in this. Let me share with you that the objective which now I can come to a part which is not really related to ICSI IIP, but when I was working with the government and this law was under consideration of the parliament, I had the opportunity of dealing with the parliamentary committee and giving suggestion on behalf of the government how we should proceed. Unfortunately, the ecosystem which has been prepared, probably somehow the infrastructure which was needed for the organizations which are working under the authority of the IBBI, probably that kind of infrastructure is not available. The shortage of members, the delay in appointment of members in the NCLT and NCLAT obviously create a hamper or a embargo in discharging their duties in the time-bound manner which is prescribed under the Act. And I find that when we deal with this kind of problem in such platform, probably it becomes our duty as part of the regulator or an extended arm of the regulator, that such messages are conveyed to the government, so the necessary corrective measures are taken by the government to see that the insolvency and the resolution process which we expect to carry out under this act, that objective is carried out. I can again share with you, I remember when this act was not yet passed, I was sitting with the then finance minister, Shri Arun Jaitley ji, and he said that we are looking for a legislation where in case a party has not been able to deliver or company is not running in accordance with the rule, it is not only for the reason that the people are playing fraud. It may be because of their incapacity to deal with a particular situation. It may be because of change of circumstances. Such businesses must be allowed to go as a going concern. Are we really moving in that direction? That is what we mean to say. And I am very happy to share with you that whatever input we are getting from IBBI, the regulator, I think we are moving in that right direction. Only thing we need is that wherever there are flaws, we say that those loopholes are plugged by the institutions which have been created under this act. Because so far as the government is concerned, within a period of 6 months, it has already amended the act 6 times to achieve that objective. I thought maybe I'll share some of my thoughts on this platform with regard to the implementation of the act also. As Chawla ji also said, today is a very important day. It's not only Lori, it's a Bihu, it is Pongal, and day after we are going to celebrate Makar Sankranti also. My best wishes to all of you on this festival day. All of you have come and to participate in this program, and thank you for your attention, and I wish you all a very fruitful and enriching experience in this wonderful conference which is being organized under the direction of ICSI. Thank you very much.
Thank you, sir. Moving on, I request CSP Narsimhan, Vice President ICSI, to please address the gathering.
Good morning, everybody. Honorable Sri Ashok Kumar Bharadwaj, Member Judicial NCLT, my President CS Manish Gupta, Mr. P.K. Malhotra, Chairman ICSI IIP, Mr. Navrang Saini, Chairman ICSI RVO, my colleague in the council, Mr. N.P.S. Chawla, who is the Program Director for this program, my colleague in the council, Honorable former member of the NCLT, Mr. Ashok Mishra, who is here with us, Mr. Manoj Purbe, my council colleague, and other dignitaries of the dais. It's a paradox of some sort, if I may say, that neither am I an IP nor an RB. But by virtue of the position I occupy in the institute, I'm a board member of both the organizations, and that's how I'm here to address this and participate in this program today. The inaugural of this national convention serves as a vital compass guiding us through the evolving currents and complex quandaries that shape this transformative legislation. We as professionals entrusted with navigating twists and turns of IBC journey have to recognize the constant flow of amendments and advancements shaping this transformative legislation. The IBC, a testament to India's economic reform spirit, has undergone a transformative voyage. Recent amendments have injected fresh momentum. Recently, IBBI came out with various discussion papers to propose changes to IBBI regulation in order to streamline the CIRP and liquidation process for enhancing the transparency and robustness of the process. One of the proposals includes amendments proposed for the real estate projects undergoing insolvency. Home buyers who have been stuck with real estate projects undergoing insolvency can have some hope as the insolvency regulator looks to bring in sweeping changes in laws. Two proposed frameworks, cross-border insolvency and group insolvency, hold immense potential for further refining the IBC and weighing the ability to go through this complex process. Recent amendments to the IBC regulation have also strengthened the role of RVs. They can now submit valuation reports directly to NCLT, increasing transparency and efficiency. Also, for streamlining the liquidation process to make a faster and more cost-effective, IBBI has reduced the time period to complete the voluntary liquidation process from 12 months to 270 or 45 days. The important role is also played by certain rulings of the court as they stand as testaments to the constant evolution of IBC and its interpretation. IBC continues to evolve, and those recent and proposed changes showcase the commitment to building a robust and efficient insolvency regime in India. In navigating these changing currents, two pillars stand tall, namely insolvency professionals and registered valuers. The role of insolvency professionals and registered valuers are both crucial and intertwined within the insolvency and bankruptcy framework of India. They work together to facilitate the smooth and efficient resolution of distressed companies, protecting the interest of all stakeholders involved. IPs depend on accurate and timely evaluation from RVs to make an informed decision throughout the CIRP. Both IPs and RVs play a vital role in this regard. Looking ahead, the future of IBC pulsates with exciting possibilities. The framework for pre-packaged insolvency holds the potential for swifter resolution, empowering companies to negotiate outside the formal IBC process. Both IPs and RVs can play vital roles in facilitating such pre-packaged arrangements. AI-powered tools and data analytics platforms can further streamline the resolution process and enhance the accuracy of valuation. Both IPs and RVs must embrace these advancements to remain relevant and efficient. AI can significantly enhance the efficiency of case management and insolvency practitioners. Insolvency professional and registered valuers are the pillars of IBC, the architects of financial revival and the guardian of trust. Your journey is not just about balance sheets and legal nuances, but about human stories, economic resilience, and promise of bright future. Let this convention be a catalyst for collaboration, knowledge exchange, and strategic brainstorming. Let us delve into the quandaries, debate the fate of prepackaged insolvency, analyze the nuances of guarantor insolvency, and master the art of valuation in insolvency cases. Together, let us build a future where insolvency professionals and valuers are empowered, resolutions are effective, and the IBC continues to be a symbol of economic resilience and opportunity for all of us. As we embark on this year, let us embrace excellence, navigate every challenge with courage, and chart a course towards a robust and efficient IBC ecosystem. May 2024 be a year of innovation and collaboration and shared success. Incidentally, we have also listened to both the chairman, ICSI IIP and ICSI RVO in terms of the progress report which they have furnished to all of you. I, being a member of the board, I have been closely interacting with both of them. I can tell you the passion which they have for the work which they are doing for us is enormous, and they deserve a round of applause from all of us for this alone. Thank you very much.
Thank you, sir, for sharing your thoughts, wisdom and knowledge with us. Moving on, I request CS Manish Gupta ji, President ICSI, to shower his words of wisdom.
Thank you. Honorable Member, Judicial NCLT, Shri Ashok Kumar Bhardwaj ji, PK Malhotra ji, Chairman ICSI IIP, Dr. Navnang Saini, Chairman ICSI RVO, CSB Narsimhan, Vice President ICSI, my Central Council colleagues, NPS, Manoj, Ashok Mishra ji. I acknowledge the presence of past President ICSI Ranjit Pandey, past Central Council member Satvinder Singh ji, past leaders of ICSI. I can very well see Yogesh ji is here, Santosh, an ARC member, all other Bhula ji present here, past former NCLT member and regional director, Chaturvedi sir, former regional director, all other members present here, speakers, Pavadia ji, he is former IAS as well as part of our RVO as one of the independent directors. All IPs present here, RVs present here, company secretaries present here, members who have joined us through the virtual mode. Good morning to everyone. Good morning. At the outset, I welcome you all to the first ever National Convention for the Insolvency Professionals and the Registered Valuers, being organized by ICSI jointly with our own entities, ICSI IP and ICSI RVU. And the whole intent of organizing this particular convention is to have those capacity building as well as showcasing that these two professions, IP as well as RV, Registered Valuer, go in hand. We were discussing about this conference. We started about discussing this particular conference in the month of July, August, when we were organizing our national PCS, and then only that idea came to our mind. Why not to have something specially designed for the IPs and RVs? We do have the conference at ICSI especially for the practicing company secretaries. We do have a conference for corporate company secretaries, and we do have a conference for women company secretaries as well. And the national convention is everybody known about it. So we thought fit to have one more feather to be added in ICSI, and we started with this concept. We were discussing about the time, and we wanted to have it in the month of December, but everybody is well aware of that December is always being holiday mood is on for all the professionals and the judiciary. So we could not able to have it in the month of December. So that the only available date with all of us. So we thought fit to have it on 13th of January. And really thank you all for your participation and showing your interest in the discussion which are going to be taken place in today's convention. The theme, the topics which we have decided to deliberate upon are being well chosen, are being well thought of. And I'm sure the deliberations which are going to take place in today's conference, which would surely benefit each one of us in the field of insolvency, in the field of valuation, and in the field of company secretaries, because company secretaries are also the integral part when it comes to the managing those resolution plans, supporting those resolutions plans, as well as when those valuations are come into picture. Last week, I had an opportunity to share the dais with the NCLT President, Honorable Justice Ramlingam ji, and he said very categorically that we were there at the research conference being organized by ICSI in association with the Nalsar Law University at Hyderabad, and we were sharing that the dais. He said very categorically that company secretaries has to come forward and take a lead. We need to prepare our youngsters particularly to come forward and take up the challenges for the NCLT, for the IBC, for the registered valuation. And he has assured the full support from the NCLT side, IBBI side, whatsoever support would be required in enriching the qualities or the knowledge updation, whatsoever would be required, that would be done with the support of NCLT. And he only suggested you as youngsters should more often come and witness the proceedings which are going on in the NCLT. Then only I had given a representation to Honorable NCLT President. Sir, please allow our members who are going to be the members who are part of the CLDP or MSOP program to come and attend the hearings, witness the proceedings, so that they can get an idea whether those opportunities are really there for them or not. And he is very much happy with the idea, and he has assured me that whenever those representation or the schedule of those members to be attending those hearing at the NCLT, he is going to divide those students, because we have a batch of 50 students at a time. He has assured that he will divide those batches into 5-10 people at a time, and those people can be divided into all 6 benches at NCLT. So it's a great move, and I am sure with the blessing of NCLT president, our students would be able to get those chance to witness the proceedings at the NCLT. Sir, I would like to share, Badwa sir, I would like to share one small thing, that this year we have constituted a NCLT task force under the able guidance and leadership of Satvinder sir, and we have prepared one report for the uniformity of the proceedings or the challenges which are there for the professional at various NCLT levels, because all NCLTs are following different processes and procedures. Although those NCLT rules are very much there in domain, but at the same time, few of the NCLT benches, like a small example if I can say, that few of the benches are looking for the green papers to be printed on the petitions are to be printed on the green paper. Some of them are asking for the A4 size. Some of them are asking for the legal size paper. So some uniformity has to be maintained so that if I am sitting at Delhi, I can be able to file any petitions at the Hyderabad or Bengaluru NCLT benches. So that we have constituted a task force wherein members from all the cities where the NCLT benches are there have been taken into this task force, and we had n number of meetings, and that report has already been prepared. We will be presenting this report first before our council on 18th of January, and will be present that particular report with our recommendation to the NCLT president very soon, sir. So we'll be looking for your help and support in those processes to be established at all the benches across India. Would not take much of your time, because the theme achievement, challenges and expectations are very much there in the domain, and the way insolvency laws, register valuation laws have been progressed up to this time. There are so many opportunities and the recognitions available for the professionals. My only request to each one of you, please, whenever you are taking up any such assignment for the register valuation or for the resolution plan or for the CIRP, give your best. And we are the extended arm of the government, and we are into the shoes of the government, and we need to support the thought process of the government. With that intent only, I once again welcome you all to this particular conference, and I hope the discussion which are going to take place in today's conference would help you all. At the same time, would request NPS that the discussion which would be held in next 2-3 sessions, we can prepare a report for that discussion, and we can submit that report to the IBBI chairperson as well as to NCLT president and NCLAT chairperson, so that some benefit, some outcome of that discussion may be highlighted and showcased to all the 3 wings of judiciary as well as the regulators. Thank you very much. God bless you all.
Thank you, sir. Ladies and gentlemen, moving on, we have a special release of publications for the benefit of fraternity. Comprehensive Guide to Limited Insolvency Examination. This book is for professionals preparing for limited insolvency examination based on latest syllabus. This publication also includes various case studies and case briefs. I request the dignitaries to please unveil the publication titled Comprehensive Guide to LIE. I request big round of applause here. That is the release of publication Comprehensive Guide to LIE. Next publication is IBC Digest, a compendium of research outcomes. As a knowledge initiative, ICSI IIP developed IBC Digest, which is a collection of research-based articles on various IBC-related issues. The publication contains selective research articles. I request the dignitaries to please unveil the publication titled IBC Digest, Compendium of Research Outcomes. Next publication is Voluntary Liquidation, a Handbook. This practical guide provides a comprehensive overview of the voluntary liquidation process, demystifying complexities and equipping professionals to handle liquidation cases effectively. I request the dignitaries to please unveil the publication titled Voluntary Liquidation, a Handbook. Would request a big round of applause here, ladies and gentlemen. Thank you.
Moving on, the first national convention is themed around Insolvency and Bankruptcy Code, and we all agree that the insolvency professionals are the backbone of this code. Let us also acknowledge that since the inception of the code, the insolvency professionals are working round the clock to save the ailing corporates and bringing back the distressed monies in the ecosystem. To facilitate and encourage the members of ICSI IIP, we have the distinct honor in presenting Certificate of Appreciation to the members of ICSI IIP who have done extremely well and resolved 3 or more corporate debtors as on the 30th September 2023. I would request the insolvency professionals to join us on the stage and collect their certificates of appreciation. Some of the members are present online, so I would request first those who are present here. Mr. Vikram Bajaj, please give a big round of applause. Mohammad Nazim Khan, Mr. Brugesh Amin, Mr. Manish Agarwal, his daughter, I think the wife of Mr. Manish Agarwal is here. Mr. Praveen Charan Praful Charan Dwari. Next is online, so 2 persons we are having online. Ms. Mamta Binani and Mr. Sameer Kumar Bhattacharya are also present online with us, and the other certificates of appreciation are for them. Those who could not make it to the today's convention include Mr. Rajat Mukherjee, Mr. Raghu Babu Gunduru, Mr. Ankur Kumar, Mr. Sarthip Parekh. Those IPs also are having the certificate of appreciation today but could not make it to the presentation, to the convention today. Let's have a big round of applause for all of these IPs. Congratulations to each one of you. Moving on, I request Honorable Ashok Kumar Bhardwaji, Member Judicial NCLT, to kindly address the gathering.
Mr. P.K. Malhotra, Mr. Manish Gupta, Mr. Nasiman, Mrs. Sani, Mrs. Chawla, other distinguished guests of the dais and the respected members of the assembly present in this convention. I am profoundly privileged to interact with you this morning. When I stand here as judicial member NCLT, I'll fail in my duty if I'll not mention about the commitment by my Chief Honorable Mr. Justice Ramalingam Sudhakar, the President NCLT. Since the date of my introduction with this tribunal, I could see unprecedented and very heartening commitment by Honorable Mr. Justice Ramalingam Sudhakarji to achieve the object of the code and take forward the NCLT to discharge its duty to the hilt and sumptuously. I could see His Lordship associated with the training of the members, the educating them, guiding them weekly, fortnightly, apprising them about the judgments of the Supreme Court, counseling them how to conduct in the court. It is so heartening to see that His Lordship guided and regulated right from MTS in NCLT to the members of the tribunal. I see him many times when I have to participate in the meetings of various committees presided by His Lordship. He comes out of the court, immediately he takes the meetings one after the others. In between he discharges the administrative function, and at the weekend he fly from Delhi to one bench or the other bench to ensure that all the benches function very effectively. Now, when I talk about and think about this gathering of intellects, as I often mention in the court, like it is for the soldiers to guard the geographical border of the country, and they do so even at the cost of their life. All you professionals, whether company secretaries or valuators or auditors, chartered accountants, you have the same responsibility and commitment towards the economy of the country. You are the heart and soul of the economy of the country, and the growth, credibility, reliability of the economy, as well as the confidence of the foreign investments depend upon your commitment, efficiency. The wisdom, I say, the wisdom, the prime source of the wisdom is honesty. Honesty is fountain of wisdom. Like a stream of water flow in a particular direction, and it will like to flow in that direction. If you try to interfere and tweak with it, the disturbance would be there and abnormal consequences would follow. Similarly, rules, regulation, law, procedure follow and flow in a particular direction. If anyone try to tweak with it, it is apparent and visible, and then the consequences are always unpleasant. Coming to the Insolvency and Bankruptcy Code, before this code, there was an act popularly known as SICCA. In implementation of that act, the role of professional agency was there. Only difference, vital difference I'll say, is that when the functioning of the professional agency was regulated by BIFR, the decision of BIFR was there whether to accept its recommendation or not. In the present regime, this discussion has been rested with the creditors and mostly on financial creditors. While coming to the IBC, it is experienced that the code is perceived by the people, by the creditors, not as a code with the object to put the sick company, the corporate debtor, to its feet or to rescue it. Mostly the code is perceived by the creditors as if it is more effective and more efficient law introduced by the Legislative Assembly to ensure that their recovery is thick and fast. This misconception is root cause of difficulties for the members of this assembly of intellect. While discharging their function in terms of the code, most of the challenges are faced by them because of this reason. The framer of the code thought that while they are introducing this code, they are giving only 4 functions to the tribunal, that is National Company Law Tribunal, that is at the time of admission of an application, maybe when the plan comes for approval, then maybe if there is no plan, then to order the liquidation and then to order dissolution. These are sections 7, 9, 10, then 31, 33 and 54. But practically the things are different, the situation is different. When application comes for admission, of course statute says that NCLT take 14 days and take a decision this way or that way. But when the law developed and progressed, the things are different. When code in itself had its advent, they were challenged, you all know, by filing the Swiss ribbon. Of course, the root and the moot contention was why the difference between section 7 and 9. But in a way, the entire code was under challenge. Of course, the challenge failed and the code passed. Again, when amendment came with a thought that yes, home buyers may also be financial creditors in terms of the provisions of section 7 of the code. Again, the challenge came in the name of pioneer. Yet again, Supreme Court said that no, there is no infirmity, the amendment is fine, home buyers can be financial creditors. Yet again, the builders, those who are in the estate industry could wake up and thought that no, this way a single home buyer can cause harm or damage to the entire project, and maybe many a time due to business rivalry and all, a single home buyer may have different object and intent while approaching the tribunal. Then amendment was brought in again in section 7A that no, either 100 of the allottees or 10% of the allottees can only file an application under section 7 and a single home buyer cannot come. Again there was a challenge in Manish Kumar and the challenge was upheld. Of course, the period of 1 month given in the code to amend the applications was made 2 months from the date of the judgment. Besides, when we talk about section 53 also, the waterfall mechanism and all, the things are not at rest as yet. When in the case of Rainbow, it was ruled that the claims of the statutory authorities, when the statute provides so, should be treated as secured claim and they should get priority in terms of section 53. In Suresh Kumar Reddy, a different view could be taken that no, the waterfall mechanism introduced in section 53 is the sacrosanct and should not be tweaked. But again, the review filed by Sanjay Agarwal could be rejected, and again, after taking note of this fact that in Paschimachal Vidyut a different view be taken, Supreme Court said that no, whatever was said in Rainbow is good, and the secure creditors, wherever the statute provides so, the statutory authority will be in that category. So the law is not as yet settled, and of course this change, the frequent changes pose challenges to the professionals and of course to the National Company Law Tribunal. For a long period, the Section 5, the virus of Section 5 remained under challenge. There was a stay and all, but now recently, after long wait, the judgment has come in the case of Dalip. There, Supreme Court has now said that initial stage before appointment of RP in terms of the provisions of Section 97, there is no requirement of giving opportunity of hearing, there is no requirement of giving limited notice. It is only when RP file a report under Section 99, the notice need to be given to the creditors, that is personal guarantors, and then only they should be given an opportunity of hearing. There is another judgment which has come very recently. Many of may not be aware of that. That is the judgment in the case of Sanjay Pandurang. When the judgment came, our Honorable President during winter vacation took note of it and brought it to the notice of all the members of the tribunal. It was a case where Mumbai bench of the tribunal heard an application on 11th May 2023 and reserved the orders. That order come on 19th May 2023. In the meantime, on 17th May, another promoter, that is other than the promoter who earlier opposed the application, moved an application say that no, there was no resolution, my challenge is different, other promoters' challenge was different. Then tribunal decide that application, order could be uploaded on 30th May, then a challenge could be made that probably the order was not pronounced and all. Then Honorable Supreme Court say that NCLT should pronounce the orders. Then all the members need to study Rule 146 and 150 of NCLT rules very carefully. The Rule 146 says that take up the matter for disposal immediately after hearing. Rule 50 says that pronounce the order immediately as soon as you complete the hearing, or in any case within 30 days. But then in view of the challenges made by the lawyers before Honorable Supreme Court, a concern could arise that whether in each and every application where final order is passed, the order should be first reserved and pronounced, because Section 61 provide for appeal from all the orders. It is not that this is the appeal only from the order of admission or from the order of approval plan. Each and every application wherever final order is passed, the order passed by NCLT is taken to NCLT. Then we could study the judgment carefully, and we could find that in para 19 of the judgment, Honorable Supreme Court had noted that both the advocates had presented before Honorable Supreme Court that on 17th May no order was passed at all. So these are the challenges. Of course, today I have come here to interact with you regarding the challenges and the expectation with this intellect gathering, but of the challenges are at the level of the adjudicating authority also. Initially it is the role of the tribunal, which comes under Section 7 when the applications come. Of course, the expectation is that okay, take a call within 14 days, but then in the judgment passed in Swiss Ribbon, Asa Steel, Surinder, Innovative, Honorable Supreme Court says that no, follow natural justice, give opportunity to file reply, timeline is not binding on you. Then at that stage itself, multiple applications come. Of course, in terms of the scheme of the code, the applications can be brought only by two category of persons, one who think that they can discharge the debt due to the creditors, and the second category who say that no, this application is collusive and is filed with ulterior motive. But repeatedly the applications are brought in by the promoters who are the enterprises. The promoters, the enterprises are not able to realize that as an enterpriser, when they start any entrepreneur, they take the largest chunk of profit. If the entrepreneur succeed and fructify, then he is the one who is the beneficiary and not the capital or the workman. But when the venture fails, he is unable to disassociate himself from that venture, and he make all possible efforts that there is delay in appointment of CIP, and RP should not take control of the venture to the extent he can delay it. The role of the RP comes in terms of the provisions of section 13, 15, 17, 18, 20 and 21 of the IBC. When IP is appointed, his first obligation is to make publication and ask the creditors to come forward and put forth their claims. Of course, now regulation has been changed. Earlier there was period of 14 days to bring the claim and then 90 days to bring the documents. But now there's a change. Now claim can be brought by 90 days or till information memorandum in terms of the provisions of section 29 is prepared. Of course, there are also the changes which are brought by IBBI, that now instead of taking the applications for condonation of delay by individual stakeholders or individual claimants, now RP can move an application by considering the same. But one aspect which most of the IRP, RP ignore, they don't look at regulation 6A of IBBI IRP regulation. They simply make a publication and then rest the things there. Regulation 6A provides that an individual notice should go to all the creditors. If the notice go to them, then the creditors will not come after 15 days and 90 days with their applications for condonation of delay, and the lot of exercise would be saved. Similarly, the mistake is committed when section 19(2) applications are moved repeatedly. The RP, IRP should not depend upon section 19(2), even liquidator should also not depend. There is a regulation 30 again in this IBBI CIRP regulations 2016, which says that the RP can approach the local administration, the deputy commissioner, the collector, and they can ask their help to retrieve, to collect, to collate the claim, to retrieve the record and all. And if there is a failure on their part, then an application can be moved before adjudicating authority. When section 19(2) application is filed and even when order is passed, that is not that effective. Still the promoters or the management of the CD do not cooperate, and the RP has to again come either with a contempt petition or execution petition. Again the mechanism is the same. In terms of section 424 of the Companies Act, it is incumbent of the NCLT to send its order for execution to the civil court, and the civil court will again appoint a bailiff, and the procedure will again be the same. So it is better to resort to the effective procedure at first instance and at initial stage itself. Normally I find that when section 17 exercise is done, the provision is not read carefully, and many duties which are incumbent upon the IP are left to be performed. We see the plans where at the stage of the plans the IP mentioned that okay, it will be the SRA who will continue entertaining the claims and would continue taking the decision. If the plans are submitted in this way, it is difficult to approve any plan, and even if plan is approved, it is difficult to implement it, because then SRA will take his own call, and the SRA will not act as a responsible IP or IRP or RP. He will look at his own gain only. So what is needed, that the section 17 where it provides for management of the affairs of CD by RP need to be studied and restudied. Section 18 should be studied and restudied. Here what happens the moment the moratorium is declared, of course the intent of moratorium is that the IP or RP should be disturbed least, and he should be allowed to discharge and complete his function within statutory time limit. But when the moratorium is declared, other proceedings before other forum in the tribunal, a view is taken that fine, we cannot go to other forum, then all those litigation which has to be in other forum becomes the litigation before the NCLT by way of different interim applications. Mostly those applications come for taking the possession of the property from the RP for the purpose of declaring that no, the asset does not belong to the CD and the possession should be given to the person. So these are the challenges the framer of the code might have never thought, and these challenges are not the challenges only for the NCLT, but these become big challenges for IP, IRP, RP, IRP and the liquidators. All these things are I think left to be discussed in these gatherings, which are practical challenges, while the practical implementation of the code comes. And these are not the challenges under section 17 and 18. The challenges are again under section 23, where the RP has the duty to implement the process of resolution. They comes under section 25. They also come under section 25A to authorized representative, who also is none else but an IP only. Then the challenges are again before liquidator when he discharges function under section 35, 36, 37, 38, 39, 40 and 41. That is accepting the claim, consolidating them, verifying them, evaluating them and taking a decision regarding acceptance or the rejection of the same. The vital area where I will like to draw your attention that IP need to be very careful is the PUFE, avoidance applications. Section 45, 43, 56 are absolutely different and unconnected provisions of law. When we talk of section 43, the section simply says that when dues are there payable to the person to whom those are given. Of course, they should take their turn in terms of section 53, in terms of the waterfall mechanism, in terms of the provisions of the code, and nobody should be given preference. The CD should not be allowed to make the payment of someone in preference over the others to defeat section 53. Section 45 says that when the value, market value of the property is different, it should not be allowed to be gifted. CD should not be allowed to sell it for a lesser value. Section 50 says that the CD should not be allowed to create such liability quote the CD, quote the company, which are of course extraneous. Like somebody may say that all right, I take loan from somebody at the interest at the rate of 50% per month, then this is an extortionate transaction. The fraudulent transaction under section 66 is a kind of transaction where the management is not vigilant and careful, where the promoters are not vigilant and careful. So intent, the object, the area, the scope of all these provisions are different, but absolutely we feel dismayed then when a single application is filed, when the scope is different, when a FIR is lodged under IPC and all. It doesn't happen that when an offense is committed, then okay, whatever offenses are there in the IPC all will be mentioned. Similarly, when the application is moved, it should not happen that in single application all these allegations are made. When in Anuj Jain case, the Supreme Court could draw the attention to this fact that no, don't mention all the provisions, there are different provisions. Then what happened? Even when different sections are violated to a single transaction, then different applications are filed regarding that transaction also. There need to be an independent application of mind. We should not get sway. The law is not arithmetic. I often say that, of course, earlier there was lazy principle applicable, but now in the code it is not permissible. That is law, logic, justice and equity we should follow. So there should be independent application of mind. Here in the PUFE application, when most of the things are dependent upon forensic audit, we find that the forensic audit reports are vague and nebulous. They are not centric. When the object is to be achieved, only facts are narrated, the lengthy report, the most of the part, the provisions of the law are reproduced, the firm is introduced, and then whatever transactions are there, those are copied and pasted as it is. Even the pictures are copied and pasted. Attention should be paid. There should be discussion on these areas, because when everything is picked up and pasted, then of course a lot of time is consumed. When applications are moved by IP, in their applications also they simply mention the transaction. They not articulate, though they do not arrive at the amount regarding which the application is filed. They simply say that okay, this is a violation of section 43 and then pass the order. How it is expected from the tribunal that it will keep on going through the forensic audit report, running into hundreds of pages, then we'll find out that which amount is payable, which amount is not payable. So when those applications are drafted, it is expected that IP read the report carefully, he should discuss with the forensic auditor, then he should specifically mention that this is the exact amount regarding which the fraudulent transaction has been entered into. Then when we come to the plan, of course, I really feel dismayed when I sit in the court and I find that when we refer to the plan, mostly the certificate given or required to be given by the RP in form H is referred to as a plan. The plan is different from certificate. In the certificate to be given in form H, it is the RP who has to certify that the plan is in order and in accordance with law. The scope, of interference, and you can say that assessment by the NCLT is in terms of the provisions of section 30 subsection 2, that is whether CIRP cost is paid, whether operational creditor is given priority in payment, whether dissenting creditor, that is who does not agree with the plan, is given priority, whether the plan provide for implementation, the plan provide for supervision, or the law is followed, whether there is any violation of law or not, and then whether any other provision which is introduced by IBBI is flouted or not. What is then of course there are certain technicalities like whether 29A certificate is there or not, whether bank guarantee is there or not. These are the limited things which are to be looked at by the tribunal, and RP, when they come to present their case regarding approval of plan, they should study these things. They should study section 30 subsection 2, they should study regulation 37, they should study regulation 38. Of course 37 talk of regarding capital restructuring and all, but in IBIC's case, and then very recently in Ramakrishna case and many more cases, Supreme Court repeatedly says that tribunal should be careful and conscious that it has to see that whether the provisions of section 30 subsection 2 are adhered to or not, but then the scope whether the plan is implementable. Of course the provision is in one sentence, but whether implementable or not, it has wide scope. There can be many reasons which may say that the plan is not implementable. Suppose the infusion of fund is not there, suppose the tribunal is not satisfied that the arrangement of fund which the SRA is bringing to fore are not sufficient, do not provide that plan would be implemented. Then the supervision, of course the monitoring committee is there where normally IP is present, but the tribunal can always be suspicious that yes, whether this monitoring committee would be able to control the SRA and all. Another area, which of course the judgment are there in Ghanshyam Mishra and all, but again you will see as far as code is concerned, section 32A provide the only exemption to the SRA, and that exemptions is regarding the criminal proceedings and all. No other privilege, no other facilities given. Even when we come to the exception to section 14, even during CIRP also, whatever are the liabilities of the CD, the RP has to meet those liabilities. Suppose electricity supply has to be there, bills are to be paid. Suppose any premises is kept on rent, the rent has to be paid. So there is a misconception prevailing amongst the SRAs that when they are bringing the plan, probably it becomes a duty and responsibility of the IP to ensure that whatever concession, whatever benefits, whatever are the licenses, permission they need from the governmental authorities, either NCLT will ensure or the IP will ensure. That is the total misconception. If you look at section 31 subsection 3 clause B and subsection 4 of the code, it clearly provides that SRA has 1 year to ensure that the SRA itself takes steps to meet all the requirements of the law. And when they come to IP should simply draw their attention to these provisions, and they should tell them that see, even when we run the CIRP, when we manage the affairs of the CD and all, we are bound to follow all the rules, regulation and the procedure. We need to follow the procedure. Then how can it be then SRA? When SRA has in a way purchased the entity, has purchased the CD, then he expects that it is IP and NCLT who carry the responsibility to ensure that no difficulty comes in their way. So all these things you need to be attended to. Of course, I have referred to all the things where the roles of IP and RP arises. The time is short, you all must be waiting for high tea and all. Thank you so much for giving me this opportunity. There is a lot more I can talk with you, but on some other occasion. Thank you so much. Thank you, Mr. Chawla, for using kind words for me. Thank you.
Thank you, sir. On behalf of ICSI, ICSI IIP and ICSI RVO, I express my most sincere gratitude to the esteemed dignitaries who have graced us with their presence at the inaugural session of the first ever National Convention of Insolvency Professionals and Registered Valuers. I'd like to express my thanks to Honorable Mr. Ashok Kumar Bhardwaj, Judicial Member NCLT. Sir, your hands-on experience at NCLT, your commitment to ethical conduct and transparency have served as a constant source of inspiration for all of us. Thank you, sir, for honoring this event. My sincere thanks to CS Manish Gupta, sir, President ICSI, for his continuous support. Sir, in your leadership, ICSI has achieved new heights and excellence. Thank you, sir, for supporting ICSI IIP and ICSI RVO in all its endeavors. My sincere thanks to CS B. Narasimhan, sir, Vice President ICSI, for the continuous guidance and incredible support in making this event possible. I'd like to extend my thanks to Chairman ICSI IIP, Mr. P.K. Manotra, sir, and Chairman ICSI RVO, Mr. Navrang Saini, sir. Your exceptional leadership have played pivotal role in establishing IIP and RVO. I hope together we will make the organization to new heights. Last but not least, CS NPS Chawla, sir, Central Council Member ICSI and Program Director. Sir, without you, it would not have been possible to organize this event. Thank you for your constant guidance. I express my heartfelt thanks to all of you. We are deeply grateful for the time and expertise each one of you has generously shared with us. This event would not have been possible without the tireless efforts of the organizations, the support of our sponsors, and the dedication of each and every participant. Let us extend our sincere thanks to all of you for making this event a truly exceptional gathering. Thank you.
Thank you. Thank you, Anu. Sorry, I'm breaking the protocol. It just came to my mind. My lords, thanks at the outset again. I mean, at the end, I would say the way you extempore address you gave was eye-opening. I am wondering how much you remember. I just realized while I was sitting here, while Anu was giving the big round of applause for my lords. Honestly, I've never seen anybody giving this much extempore address and in-depth knowledge, and that too when my lords have only taken over as the role as a member judicial not many years back, 1.5 years, 1 year back I think. And in this short time, my lords have got so much grasp on the subject. I just realized when Anu mentioned friends about the role played by our president. While I was sitting here, I realized that today is 13th and our lovable and young dynamic president would be demitting his office as president on 18th of January. So big round of applause for Mr. Manish Gupta. Honestly, it is my mistake. I didn't realize that this would be his last program here in his own city, Delhi. So would request Honorable Justice Bhardwaj to please present a shawl to Manish sir on behalf of all the members, and you all can give a big thundering round of applause for Manish Bhai's contribution. He has been throughout the year available, not for this year but for the last 15 years. So big round of applause for Manish Bhai and a planter also being. Would request Justice Bhardwaj to please present a small planter. Thank you, Manish Bhai, the kind of work you have done in the institute. Thank you. I can just say that many leaders would not be able to achieve what you have achieved, Manish Bhai, and the kind of time, the kind of dedication which you have shown for the profession. For the last 15 years, we are together in the Regional Council, initially 8 years and now 8 years in the Central Council. I have seen myself the kind of dedication, devotion, commitment. Institute is the topmost priority for you. I have always seen that, and I am sure all members can approach you whenever they are in need, and you will always be available for members. What you have done in this year would be certainly a benchmark for many years to be followed. Thank you, Manish Bhai, for your always available approach for the profession, for the professionals. Thank you on behalf of the entire council. I am sure the earlier council, our president, past president, Mr. Pandey, would also agree with me that the kind of work which you have done in this year, the kind of cohesive approach which you took for taking the entire council along with you is remarkable. Thank you. Thank you. I think we can come back in a short tea break. Our panelists are also here. maybe 15 minutes short tea break, and then we can reassemble for the first panel discussion. Thank you.